It looks like we have our next speakers with us. So let's go right into the next session if the gentlemen are ready. The next session is called The Impact of Employment Law on the Diffusion of AI. So let me do a quick introduction of our speakers, and I'll turn it over to them. We have Jonathan Ben Asher, who is from the law firm Ritz, Clark and Ben Asher. Jonathan Ben Asher represents executives, professionals, and other employees in employment disputes, including those involving employment contracts, executive compensation, whistleblowing, retaliation, and employment discrimination. He works with clients through all phases of an employment problem, negotiating their employment contracts, protecting their interests when problems arise in their employment, negotiating severance and buyout agreements, represents them in arbitration, litigation, and mediation. Also, we're very pleased to have with us Robert Szyba, who is a partner at Seyfarth Shaw. Rob advises employers on a host of workplace challenges from AI to cannabis policies, wage hour to background checks and beyond. He is a seasoned litigator and an ardent advocate both in and outside the courtroom. Companies face multiple layers of requirements and obligations related to employees and contracts, and clients rely on Rob as an effective and efficient strategist to defend them in lawsuits, to devise action plans to avoid litigation, and so on. Both of these gentlemen have very long and impressive backgrounds, but I'll just leave you with the abbreviated version of their background so we can jump right into the presentation. So Jonathan and Rob, I'll turn it over to you. I understand you don't have a PowerPoint, which is fine, so you can just talk to us, and we'll have some questions for you at the end.
Okay, thanks very much. So, welcome everybody. I think what David said at the beginning was very instructive, which is that after a huge amount of hype and hubbub about AI, there are now constraints that are developing that should make investors and entrepreneurs think critically and thoughtfully about what they're going to do because of the issues that are so important for employers and for employees. So what we're going to talk about are three things. One is the critical ways that employers are using artificial intelligence in terms of their relationships with employees. Two is what legislation and regulation has been enacted and is coming up to regulate the employment relationship in terms of how AI deals with it. And finally, what's happening in court cases that may affect the companies that you invest in. So how are employers using artificial intelligence? Well, they're using it all over the place. A survey last year of 1,000 senior decision makers showed that only 2% of employers weren't using AI. 2/3 of them were using it in terms of dealing with their employees, and the rest were either thinking about it or had a pilot program. Employers, as David said, hope that by using AI, they can reduce costs. They can reduce costs by reducing the number of the headcount in their companies. Most of this is not good for employees, and a lot of it is not good for job applicants. And it poses a lot of risks for employers that investors have to seriously think about as they're making their investment decisions. So I'm going to talk a little bit about each of these tools, and then Rob is going to chime in with his perspective. So how are employers using AI first to get people on board? First, they're using AI in recruiting tools on social media to attract candidates, and they frequently use tools that are targeted to very particular subsets of users. So AI allows employers to direct job ads to particular populations, and they have to be very careful about this because doing this, they put them in legal jeopardy because under various federal and state and local civil rights laws, it's illegal to discriminate in hiring employees based on membership in protected classes. In 2019, the ACLU, American Civil Liberties Union, filed a charge with the EEOC saying that one social media giant had an algorithm that allowed advertisers to deliver these job ads based on gender and age. And because of the charge, the company agreed to modify how it was handling the stuff on social media, but studies show that their revised algorithm still let them do it. So for example, the revised algorithm let them direct ads for AI jobs to men and let them direct ads for supermarket cashiers to middle-aged women. So let's say an employer has put its ads out, which are sifting through candidates using an AI tool. They then have to rate those candidates. They have to evaluate them. So how do they do that? Well, 2/3 of most employers have been shown to research potential candidates by looking at candidates' social media profiles. And the problem is that the tools that rate these social media profiles can be biased because of the data that goes into the algorithm. One large company used to have a pilot project, which it eventually abandoned, which allowed the company to screen resumes for certain jobs by comparing them to the resumes of current employees. Well, the problem was that most of the current employees were men. So the algorithm was screening out resumes that had any references to the word women, like women's lacrosse team or women's soccer. Some algorithms actually go further. They look at a candidate's social media profile and create a personality profile, a personality test, based on the data that's in the social media profile. One tech company had a tool that rated candidates based on the social media profile on all kinds of personality traits like openness, neuroticism, agreeableness, extroversion, conscientiousness, dominance, influence, and teamwork. Nobody really has any idea whether or not these ratings are actually valid, or if they have anything to do with the job competencies that are necessary to evaluate whether or not somebody should be hired into a company's workforce. So vendors often sell these AI tools that review candidates' social media activity, but companies, investors have to be very, very careful, and they have to look into the black box and figure out some way of evaluating whether or not these tools do either of two things. One, do they effectively rate the candidates based on any kind of scientific metric which has validity for a job competency? And secondly, does the algorithm discriminate in any way? One of the big issues that has come up in terms of people applying for jobs is what happens when somebody has a disability and they are being interviewed by an AI bot, and the bot doesn't properly evaluate how that person expresses themselves. And these job interviews that some tech companies are selling are particularly problematic because the tools ask candidates questions and evaluates them with little or no human input. So one example of why these things can be quite defective and useless and why investors should be careful was shown by an MIT study. The MIT study had a candidate posing for a position, they were really part of the study, that required very strong English language skills. And what the candidate did in 2 interviews was simply respond to the questions by the bot interviewer by reading a Wikipedia entry in German. And the AI tool thought she was tremendously qualified for the job, said her English skills were fantastic, and would have hired her. So employers have to be very, very careful about this stuff. Employers are also using AI tools to evaluate people who are performing jobs on how they do. Sometimes they're looking at how fast they're hitting the keyboard, how many keystrokes they're handling per hour. Well, there's many white collar jobs, of course. I think most of us on this call have them, where we're not touching a key every single second of the working day. We're thinking, we're collaborating, we're brainstorming. We're trying to figure out what we should do before we hit a key and memorialize something on paper. The other tool that's often being used by employers is this thing called continuous feedback, which is a smart thing for employers, I think, although it may be a big hassle for employees. What it does is have an AI tool constantly give the employee feedback on their performance. Why is this good for employers? Well, it prevents a situation where an employee gets a review every 6 months or every year, and the employee has gotten a fantastic review on January 1, 2024, and doesn't get any feedback until November 2024, and then is brought in and told that they're being fired because their performance wasn't good. Well, this tool can be very useful for employers because A, it gives the employee continuous feedback about their work and maybe they can improve. And secondly, it prevents the employee from saying, I didn't know anything about how I was supposedly not doing well, because that feedback is continuous. So I'm going to turn it over to Rob now to give the employer's perspective, which may be very different than some of the cautions that I've given you.
Thanks so much, John. I really appreciate that. I don't know, John, I'm not really sure that my perspective would be really all that different. The one thing that I might kind of add to what you had said, number one, we see a lot of statistics these days about who's using AI, how they're using AI, what they're doing with it. And I have to be honest with you, I find it to be largely unhelpful and sometimes misleading, and I'll tell you why. Studies that have been done about which companies are using AI, I think, can be flawed sometimes because, number one, that number increases every day. So today, there was a slew of companies that, for them, it was their first day using some sort of artificial intelligence. And that number will be different tomorrow and the next day, and next week there'll be more. So these numbers are increasing very rapidly and on a daily basis. Statistics that talk about how companies are using AI or which tools they're using AI for, the older that these statistics are, I think the more detrimental it is to rely on them. The other thing is, a lot of companies and a lot of employees of companies that respond to these types of surveys and inquiries might not even realize the types of AI that they're utilizing. They might be utilizing AI without realizing it, which I think that probably happens in the general public at large. I think we utilize a lot of different tools, whether it's doing something as simple as a Google search, which was using AI before AI was really top of mind and before it was really being disclosed. So I think looking at these sort of data points can be a little bit misleading. It's interesting, anecdotally probably, but probably not extremely reliable. The other thing is, I think the only bounds for the uses of AI are the human creativity that drives the development of these types of tools. I've run into companies that utilize artificial intelligence in a variety of different contexts with respect to their employees that even I've been surprised about. For example, one not so shocking, but one great utilization of artificial intelligence. A couple of years ago during the pandemic, one of the hospital systems in New York City utilized artificial intelligence to screen millions of resumes of nurses to get people staffed very quickly, to find good candidates very quickly, something that if humans were doing it, they would be incapable of doing that type of volume. I've seen artificial intelligence that will conduct job interviews. We'll ask questions and we'll take in answers and we'll respond and we'll do a variety of different things, assess the merits of the responses, assess the language skills of the candidates. We've seen facial recognition software that's been utilized, all kinds of things. The one thing that I think consistently comes up when speaking to developers of these tools and companies that utilize them, I've yet to run into one that has told me that they expressly want to discriminate. No one is looking to do that. Everyone is looking to either develop a tool that will minimize bias, that will limit bias, that will reduce the risk of discrimination. There have been flaws. There have been AI tools that have gone off the rails and have deviated from their mission. But by and large, they seem to be the exceptions by far, as opposed to the rule. That said, I'm not really sure that we have a great way of testing it. No one is double checking the artificial intelligence tool by reviewing those million resumes to see if there in fact was bias. We're just incapable of doing that. What has emerged, on the other hand, has been ways of doing that by running statistics, by taking a look at how many resumes were there, what was the population of individuals that were selected, And we're doing some of that with data analysis, but it's relatively a new utilization of those concepts, and we're probably at the very early stage of doing a lot of these types of testing. Among the things that has come up with companies that utilize artificial intelligence is also, and I think it's the fear of the unknown. Do we really know what's going to happen in the future? Are we all going to lose our jobs? Is everybody going to be replaced by a robot? That fear, I think, has been growing, but really kind of taking place for the past couple of years. There are a lot of jobs that are predicted to be eliminated. There are a lot of jobs that are expected to be replaced by AI. I'm not sure if that's true. I too have seen the Terminator series and the Matrix, and I have my own worries that are fueled by perhaps science fiction, although I don't know, the first 30 minutes of some of those movies seems to have come true already, so who knows? But I often think of a client of mine that hired their first robot to work in their restaurant as a food runner. And my immediate response was, that's great. You're going to save on staffing. You're going to save on, paying your employees. You're going to have fewer employment issues. The robot's not going to call out or get sick or have some sort of issue that they can't come into work. That's great. So how much did you reduce your headcount? And what was really kind of surprising to me is that the employer in that context said zero. We didn't have to let go of anybody. In fact, utilizing that robot to assist with food service has allowed our wait staff to spend more time with customers, to spend more time talking about the different food options, to be able to engage with our clientele on a much more meaningful level. And I think that is a really great example, although I'm sure not everybody here is opening up a restaurant tomorrow. But I think nevertheless, some of the fear about jobs going away and being replaced is probably valid, because some things will be eliminated and some things will evolve into different version of them. Just like however many decades ago it was the folks that were working the line at the car manufacturing plants were obsolete eventually. But I think there might still be a lot of need for human interaction or the human touch. And I say that in part because while we talk about a lot of these AI tools, and to my earlier point that there's a very limited way of testing them, other than statistically sometimes, I am often reminded of the limitations of AI and its relatively infantile stage, at least from my perspective. And I'm reminded of that every single time that I try to text message someone, and the predictive texting or the predictive, software that's being utilized in my app comes up with the darndest things to say that I don't really mean to say. And as much as it seems sophisticated to say that I've got this cool AI thing that's going to help me write my text messages, the reality is it's still very much in its infancy. That may not be true for long, but at least for the time being, I worry that we're putting a lot more faith into AI than is merited, at least at this stage. So, kind of circling back to the topic at hand, as far as how these tools are utilized in the workforce and with respect to employees, John, I think you're absolutely right. I think there's a lot of different ways that they're being used for recruitment, hiring, and selection, productivity, managing performance. And as we go, as time moves on, we'll probably find artificial intelligence to be woven into each of those stages and more. It's really only increasing. Every day I seem to be reading about a new tool or about a new device or about a new something that's solving a problem that developers somewhere identified and came up with a solution for. I'm not sure they're all great fixes. I'm not sure it always works. I'm not sure that it's the best idea. But there is definitely a lot of energy around infusing the work relationship with artificial intelligence. oftentimes driven by the intention to eliminate human bias and human sort of predispositions and stereotypes and discrimination type concepts.
You know, I would agree with you that no developer and probably no companies are thinking about creating and using an AI tool because it discriminates. I don't think that, you know, developers are trying to develop those tools. I don't think employers are focused on using them. The issue that I and a lot of other employee side lawyers have is a broader one. And this implicates what is happening on the legislative front, which is that, as you said, there's no broad-based, agreed-upon way of evaluating whether or not these tools actually measure what they're supposed to measure. And so the tools, a lot of them fall into a black box that even the greatest of minds can't evaluate. And so the issue is that these tools are out there. There's proclamations from the tech vendors about how they function and what they measure, but nobody really knows, are they actually doing that? The legislation that's been introduced around the country doesn't really attack that problem either. Most of the legislation that we see focuses on the issue of discrimination. And as Rob said, whether or not an AI tool and the application of an AI tool is going to discriminate against protected classes. So in New York, which has a very broad definition of protected classes, those classes might include age, race, gender identity, disability, and a whole list of other protected classes. Similarly, other states with similarly broad human rights laws would have statutes with the same ambit. Now, the law that got all this stuff going and created so much discussion was a New York City law. And the reason why it's significant for employers and investors is that it's not limited to just companies that happen to have an employee who's working in the 5 boroughs of New York. It's because it covers anybody who has a job location, which is in New York, either full-time or part-time, or is remote, but associated with a location in the city. So what this means is, if I have a company in Ohio, and I have a company in New York, and I have an employee in Ohio, and that employee in Ohio reports to a location in New York, this law covers them, it covers me. So what does it purport to do? Local Law 144, which is what it's called, says that you can't use an AI tool to screen a job candidate or an employee for hiring or promotion. So this theoretically would include evaluations of employees that go into a promotion decision, unless that tool has been subject to a bias audit in the previous year. Those bias audits have to be posted publicly by the employer, and employees have to be given notice of the fact that that tool is being used. Now, that all sounds great, except for 2 problems. One is that there's no ability of the employees, either on an individual basis or class basis, to enforce the law. There's nothing they can do. The enforcement is from the New York City Corporation Council, which is the legal office representing New York City. And that office has way too many cases already to start delving into this stuff. There are civil penalties, but so far, I don't know, Rob, maybe you've seen something different, but I haven't seen any civil penalties, any enforcement action by the New York City Corporation Council at all. So to my mind, it's a very weak law, and it hasn't really done much. There's another law that employers have to be aware of, which hasn't gotten as much publicity, which has to do with electronic monitoring. And it is buried and not very well known about, but it's part of the New York State Civil Rights Law, and it covers all employers which have a place of business in New York. That's very wide. It requires a prior notice to employees when they're hired, that employer is going to be doing monitoring. It covers people who are coming onto the workforce and current employees. It's also enforced by the Attorney General's office with possible civil penalties, but I haven't seen any cases flowing from that law so far. But what that means is if an employer is going to use a tool to watch an employee work and to check their keystrokes and to evaluate their work, they've got to give the employee notice. Now, unfortunately, from my perspective as an employee lawyer, it doesn't go far enough. It doesn't give the employee, as some statutes do, the ability to opt out of that, but it's still there. There's been a lot of legislation in some other states that is broader and possibly more effective than the New York law. So I'm going to turn to Rob to explain some of those statutes and regulations.
Sure, John. So one of the things that I'll start off with is that I really don't want to say I disagree with you. So I'll add to what you're saying. The first thing I'll add to is that I think you're absolutely right that there really has not developed a great system of measuring these tools. And I think that's a huge point of frustration for a lot of employers and companies. The laws that we're kind of working under in this discrimination context is usually founded in like anti-discrimination law. So for example, Title VII, the state counterpart of the New York State Human Rights Law, and various other state laws across the country that basically say discrimination is prohibited. When it comes to specific tools like artificial intelligence, other than the local law 144 that I'll touch in a second, there really is not sufficient guidance as to, okay, well, we can't discriminate. What are we supposed to do? What is it that you want us to do? What are the standards for that? With artificial intelligence, it's such a new technology, it's such a new application of that technology that really hasn't emerged. So we're really very much in the infancy. Many people agree that there should be some sort of guardrails or standards, but the issue is that we just don't have that yet. To your point about local law 144, I kind of look at it a little differently. I think a lot of people criticize that law that it, didn't do enough, or I think some people call it toothless, that it didn't really accomplish anything. But from my perspective, I look at it a little differently because I dealt with a lot of companies that were trying to get into compliance with that law when it went into effect. The first point of frustration, kind of really interesting, is the office that was charged with enforcing it and providing guidance. I was in regular contact with them, and I don't know, maybe about 6 months before the law went into effect, and it was already on the books for about 6+ months. They hadn't figured any of it out yet. They still had no idea what was going on. In the months leading up to it, I was having a lot of conversations with that office up until at one point, my main contact there calls me up and says one day, well, I gave notice I'm not going to be here. And I said, oh, that's too bad for us. What are you doing next? And he says, well, I'm going to go to law school. I really enjoyed my time working on this artificial intelligence law, and I want to go to law school. And I said, well, what do you mean you're going to go to law school? What have you been doing? What's your history? And he says, well, I just got out of college, and it was like my first job out of college, and I thought it was pretty interesting. John, my jaw hit the floor when I realized that I was advising Fortune 10 companies on how to comply with an artificial intelligence law in New York, the first of its kind, based on the opinions of effectively a college kid. But I don't think that's unique. I've had that experience or something similar with a variety of different government agencies where there will be a concrete question, and the answer is we don't really know. We haven't really thought about it. Nobody ever told us that. We didn't think that's how it worked. So I think there's a huge learning curve with this law. But what local law 144 did accomplish, from my perspective, is that a lot of companies started to really focus on their artificial intelligence tools. There were companies that stopped using AI in New York City to avoid complying with local law 144, having to go through the steps to get into compliance. There were companies that realized their tools weren't working as effectively as they should have been and fixed them. There were companies that went through the steps, and a whole cottage industry emerged of bias auditors all across the world that will take your AI tool and for a price will run it through the tests and will produce a report, and you can post that report that you got a bias audit and it passed with flying colors. At the end, New York City's law was the first of its kind. It has really driven the conversation regarding, is it a good idea to have a bias audit requirement, a bad idea, can we do it better? And to your point about other states, I was just on a panel with the state senator in New Jersey, Senator Zwicker, who proposed the law in New Jersey, just across the river, and flat out said, proposed the law. We wanted to make sure that we were, keeping up with whatever our neighboring jurisdictions were doing, but it hasn't passed yet. And we look at that as an opportunity to see how it's working out, and are there things that we could do? And we want to be the ones to pass the 2.0 version of that law, the one that's been vetted, tested, and now works a lot better. And I think that's probably true with a lot of different jurisdictions. Government agencies like the Equal Employment Opportunity Commission and state corollaries have really weighed in on what a lot of these types of tools do and how they work, and have kind of issued reminders universally saying that there are already laws in place that prohibit discrimination. They apply to AI just as much as anything else, whether it's a federal law or a state law or a local or municipal law that has certain requirements. And universally, I think that's probably appropriate and right. That these laws that prohibit discrimination, it really doesn't matter what if you're using a notepad and a paper or a chisel and a stone or the latest AI tool. If it's producing a discriminatory impact, it triggers that law's applicability. These additional laws that we're talking about really go into ideas about additional requirements specific for those tools. And John, to your point earlier about these laws, there are maybe about half a dozen jurisdictions across the country that have proposed laws similar to New York's that require an annualized bias audit and reporting obligations. There is a swath of proposals all across the country that talk about creating a committee or a task force or some sort of group of people to study AI further and come up with further proposals. And there's a handful of one-offs. For example, Chicago's facial recognition law, the law in Maryland dealing with interviews, with video interviews, one of the proposals in New York about an AI Bill of Rights. So there really is emerging a hodgepodge. But even there, I think a lot of the state legislators recognize that it takes a long time to pass a law at the federal level. And at the state level, they have constituents, they have voters that they need to make sure that they're being serviced. And they oftentimes work at a quicker pace and can propose laws at the state level, recognizing that they'll be first, and then the federal government usually will take something on after it's bubbled up sufficiently at the state level. So they're looking at it from that standpoint. One other thing I wanted to point out, John, I know we want to talk about litigation for a few minutes. Actually, I'll let you start the litigation piece because there's a tie-in between the laws and something else I wanted to point out in terms of your comment about the laws applying to people across state lines and developers as well as employers.
Well, thanks. One more point on all these laws, which is that I had an interesting experience over the last year being part of a lobbying group that was going to legislators and staff people in the New York State legislature to try to get the passage of an AI bill that would protect employees more than local law 144 does in New York City. And the bill didn't pass because there were a lot of political hoops to go through that never went through. And there's going to be another bill there are already several bills that have been introduced in the legislature this year. If those don't come through, there'll be more next year. But what I learned from doing that was that if I were an employer, I might very well not use AI at all, simply because the cost and the hassle and the difficulty of understanding how to comply and how to do these bias audits are huge. The other point being that if you read the statute and you're not immersed in the world that the statute comes from, it will give you a migraine to read some of these laws because they are so long and so involved and so filled with definitions that are not common definitions of words that it makes it very, very difficult for someone who is not a specialist in this field to understand what a company has to do. And it may be that the side effect of some of these laws being passed is that some employers, particularly small employers, will say, we don't need the hassle. We just don't need it. We're not going to use AI. It's not going to help us enough so that we want to put ourselves in legal jeopardy. The other issue about some of these laws is this, as I alluded to before, enforcement. It's very, very hard for a single plaintiff in a case to prove that a company had made an employment decision based on a prohibited AI tool. How is the discovery going to be handled in that kind of case? Does a single plaintiff case offer an opportunity for a plaintiff to prove that the requirements of an AI bias audit, which are enmeshed in these statutes, were not met? And it may be that the only way for employees to remedy any violations of these rights are in class actions. But you and I both know that class actions are becoming much more difficult for employees to bring now because of class action waivers that are being built into a lot of offer letters and employment contracts. So to finish up on that, let's move to litigation. There's been a lot of cases all over the country that employers should be and investors should be aware of that have addressed equal opportunity issues that are created by the use of AI tools. So Rob, why don't you talk to us about that?
I think two things to kind of note in terms of litigation, big picture. A couple of years ago, there was a case involving tutors by a company called iTutor, a company out of China. It was heralded by some as the first case decision dealing with artificial intelligence. It wasn't. The tool that they were actually utilizing was just a very basic rule that disqualified men based on, I think it was 60 and women on 65 from being hired. Company out of China, the EEOC went after them, sued, eventually got a decision in their favor, and the company effectively just stopped doing business in the US and said, we're just going to leave. So that case came and went. It made a lot of noise, but it really didn't add much to the conversation. Currently, there is a case called Mobley versus Workday in the Northern District of California that is being litigated. It stands to probably be the blueprint for what a lot of future cases will look like. The plaintiff was a job applicant who had a number of different issues that were protected under the law, from disability, age, race, etc., and alleged effectively that he applied for over 100 jobs through Workday, all companies using the Workday system, and he got not one call back. And he said he was qualified for most of those jobs, overqualified for some of those jobs, that there's no other explanation other than there was something nefarious going on, that he didn't even get one call in response to his resume. That is being litigated right now. The very important takeaway so far, what's happened in that litigation, is that Workday is not the employer. The actual employer was a different company, but he's suing the vendor of the company that he applied to work for. There was a motion that was filed that really focused on the fact that under federal law, especially, employers are prohibited from discriminating against prospective employees. There's no mention of vendors or employment agencies or ATS systems or anything like that. And so far, the decision that came down in that case, in response to that earlier motion, was that if there is a vendor who is basically stepping into the shoes and behaving as an employer or doing a function that is traditionally performed by an employer, they can be liable under Title VII, under federal law. So if you have a vendor, for example, that is taking a piece of the recruitment process, the onboarding process, if they are performing the employer function and effectively stepping in the shoes of the employer, they may be directly liable under Title VII. An important thing to point out And this is going to vary from state to state, but a lot of states do have this. New York is the prime example. New Jersey is another good example. There are states across the country that have this. State versions of a lot of anti-discrimination statutes have built into them what's called liability for aiding and abetting discrimination. So I might be the employer, and my colleague on the left might be, the vendor, the whoever, another entity that's involved in this employment relationship globally. If they do something or don't do something that leads to a discriminatory impact on the employee, they can be liable. There was a case in New York a couple of years ago, where a company out of Illinois that had nothing to do with New York, had no business in New York, had nothing other than the fact that they had their customer was a company that was in New York that had an employee that they fired. There was a background check company, the one in Chicago. They were pulled into New York because of that aiding and abetting concept under state law. So even though there was no basis for liability under federal law, New York state law was nevertheless used as a hook to pull that company in from Illinois into New York and potentially liable for aiding and abetting the discrimination that was alleged to have happened in New York. So these different layers of laws and statutes and court systems are an important thing to keep in mind, because even though a certain rule or a certain statute or a certain law might be enforced a certain way at the federal level, state laws operate differently, and state laws can create a lot of havoc for employers that don't necessarily pay attention to those. And in recent years, to make matters even worse, it's not just state laws. Increasingly, we're seeing a lot of county level and the city level jurisdictions trying to get into the game of writing laws for employers. New York City is the prime example with local law 144. Chicago is another prime example. San Francisco, Los Angeles, Austin, Texas, Philadelphia, Westchester County, New Jersey, Westchester County, New York is another one. So they might take a specific issue and legislate on it that can really create a lot of issues for employers that are not drilling down that deep to figure out what some of these legal requirements are. And whether it's a county law or city law or state law or federal law, a lawsuit is a lawsuit, defense costs no matter what. And sometimes the state statutes provide for greater liability than the federal statutes. They might be more limited in scope because of state borders, but sometimes they'll have uncapped damages and things like that that make them very important to pay attention to.
Yeah, that's a very important point. And a footnote to that, Rob was talking before about the federal level. And here's a big unknown, because under the Biden administration, the EEOC, Department of Labor, they were very, very much focused on looking towards regulating how employers use AI tools. And the EEOC promulgated 2 guidances to employers about how they can use AI tools when it comes to cases regarding age discrimination and disability discrimination. Those guidances are still there. And the AI Bill of Rights that was promulgated by the Biden administration is still in existence, but you won't find this stuff on the internet. It just disappeared. So we don't really have any way of knowing what's going to happen over the next couple of years. There was an EEOC commissioner, Keith Sonderling, who, although he was a Trump appointee, was very active in going around the country and speaking to lawyers and employers about how they have to be careful about how AI tools are used in the employment context. He left the EEOC. So a lot of this is a big unknown. So I think we have a few minutes for questions. David, is that right? Do we have any questions?
Yes, we do. There's a lot of interesting questions here. It's difficult to choose which ones to ask you, but maybe touching on a few things we haven't discussed so far. Maybe can you talk about how AI, the ability of AI to displace maybe manufacturing workers? So if there's a new line of humanoid robots that can displace 1,000 line workers on an auto assembly plant, talk to us about the challenges. What do the unions say about that? Do you have to buy out the workers? How much notice do you have to give? It's not so simple just to roll out humanoids, I would imagine.
Right. Well, I'll just briefly comment on that and then turn it over to Rob. If all the humanoids are being replaced, that company is subject to the federal and state WARN Acts, which means that notice has to be given and a certain amount of departure pay has to be given. And those statutes are very, very clear and very specific about what employers have to do, and the potential for liability is pretty big. Rob, you want to talk about any of this stuff?
Yeah, no, I'll add to that since the comment was made about the unions. I think that's exactly right to identify that issue. Every workplace, every company, it might be subject to different nuanced rules, but if there is a large portion of the work site that is being now transitioned to robotics or some other types of non-human tools, that is absolutely going to be something that the union is going to need to bargain over, and that will very likely be a big point of contention. So that's exactly right to identify the issue. It's a little unclear as to, what the nuances of that are, because every workplace will be a little different. But I think the blueprint for a lot of that conversation already happened in some of the industries that we've already had, the automotive industry being a very prime example of that. And we've kind of watched how that's played out. So that will probably be where at least some of the fundamental road mapping of how to approach this will probably come from.
And one more comment on that, which is that it may be that the people who are the greatest threat of having their job eliminated are white collar workers who write. And some of the white collar workers who spend most of their time writing are lawyers. And we have seen how vendors have come up with tools that would allow much of the work at law firms that's being done by paralegals and early young associates to be done by an AI tool. And they don't do it that badly. So lawyers have to watch out. Lawyers have to watch out for what might be coming their way.
So another question, if we go over a few minutes, we'll yield back the time to Kevin at the end of his session. What's going on with hiring foreign programmers? So if we have an American company and we hire programmers in Romania or Bulgaria, what's happening on the legal front there? Does the data have to be kept on our servers? And at what point does national security come into this? What point do export controls or dissemination of very powerful data have to be approved by the government?
Well, as President Obama said, that's above my pay grade, but I can say this. Under the New York City law, a Romanian employee who's reporting in to a New York-based employer, they're covered by that local law 144, right? Now, whether or not there's a national security implication, that I don't know. But in many jurisdictions, workers who are outside the jurisdiction, who are reporting into an office in the jurisdiction, those workers may very well be covered by local laws regarding AI and perhaps local human rights laws that prohibit discrimination on the state or the local level.
Yeah, and I'll just add to that. I think that the concept of where data is housed and data security is a little bit, not necessarily dealing with AI in terms of the employment context, but that will also very heavily depend on which jurisdictions are at play. Your relationship with the European Union, Romania, is going to differ when you're dealing with companies that are, in South America or Africa or Australia or something like that. The way that those laws pair and the way that those considerations have to be analyzed is going to be a little different. But I think you're absolutely right to be looking at it from the perspective that you have to be sensitive to both nations' laws and figuring out how to navigate and structure that relationship. And if you have developers in multiple jurisdictions, that becomes that much more difficult.
Yeah. David, as you said at the beginning, the European Union is very far along, far more along than any jurisdiction in the US in regulating how entities, not just employers, but all entities have to use AI. And they rank the use of AI in accordance with basically a level of risk that's involved. And US companies that do business in the European Union are covered by these laws. They're very strict, they're very clear. They're going into effect pretty soon, And if I were company counsel, in-house counsel, at a company who was doing business in the European Union, that's absolutely critical to look at.
Mhm. I'm going to try to squeeze in another question. So you talked about AI at law firms. You're both lawyers at law firms. Is professional liability insurance premiums, are they going up or down? Going down because AI is so smart, it won't be any mistakes, or because AI is new, there could be mistakes.
Yeah, well, as you know, I'm sure you've all heard of the lawyers who got sanctioned because they cited several cases that did not exist anywhere here or in the Twilight Zone. And so the risk to lawyers who are sloppily uh, applying AI and not looking at every single case that AI might find and reading it, as human beings are required to do, to know that the case actually A exists and B stands for the proposition that it's being cited for in a legal brief. Those lawyers are going to have malpractice problems, certainly. And if I were an insurer, I would raise my rates to reflect that. Absolutely.
A lot of professional liability insurers are also chiming in on the topic and having their own requirements or trainings or standards that they're passing on to their insureds. At the end of the day, John, to your point, lawyers are regulated at the state level. Every lawyer is licensed by a certain state authority, and every authority that's tackled this question has really come up with the same answer, which is at the end of the day, whether you're using AI or anything else, the lawyer is responsible for the ethical obligations that attach, regardless of whether it's AI or not. So it's to your detriment if you're relying on AI and not really vetting what's happening.
So does that mean the lawyer's fees are going down if you can use AI and instead of taking 5 hours to write a memo, it takes you 2 hours? With the professional ethics and stuff like that.
Yeah,
It's very
sometimes.
interesting that you pose that. Rob and I were at a conference a couple of weeks ago where some of the vendors who market tools for lawyers were talking about exactly this. And the issue, of course, it raises is that many lawyers, like Rob and I, do bill their clients often on an hourly basis. So, will there come a time when a client will say, looking at those cases and writing that brief that could have been done by an AI tool in an hour, and your retainer agreement is providing for you doing that, and you took 5 hours to do it? I don't want to pay for that. So, this could very easily be a revolution in how law firms bill.
Okay.
Yeah, I do want to raise one thing though, to your point, John, about it might take an hour and I don't want to pay for the other 4. Look back to your comments a few minutes ago about the lawyers who wrote a brief, didn't check it, and got sanctioned.
Right.
So yeah,
Right.
it rolls off the tongue very easily to say that oh, we don't want to pay for the other 4 hours, but you get what you pay for. There's I can't think of any lawyer that I've ever met that walked around saying, I can't wait to spend more time doing something so I can just bill my client. Most lawyers advertise the fact that they can do things efficiently and well. So there is a natural control on the ability of one law firm to go to market and be able to say, we can do a lot more for a lot less time and save you a lot of money. So I think that going back and saying I don't want to pay for the other 4 hours because AI could have done it faster, then the answer is you should have gotten the AI.
You could probably raise your rates because your professional liability insurance premiums are going up. So that's a good excuse to raise your hourly rates, maybe.
On that question, I think there is an instructive analogy here, which is that I think we've all heard that an AI tool can read a radiological test with greater efficiency and accuracy than radiologists, right? We've seen that. But it would be a mistake to think that a lot of what lawyers do, which is assessing risk, right? What are the strengths of this case? What are the weaknesses of this case? What's the risk that this case could go forward from step A to B to C to D? What's the settlement value of this case? That can be replicated by a tool, because that involves a huge amount of human judgment and a huge amount of experience. And I just don't think, and maybe I'm just being, naive here, and eventually I'll be proven wrong in 50 years or 5 months. but I don't think that an AI tool can substitute for that kind of judgment. It may be able to substitute for reading an X-ray, but I don't think it's capable of replicating human judgment that comes from years of experience in analyzing legal issues and projecting possible risks and benefits.
To your point,
Right.
John, the lawyers that we tend to hear about most often and the ones that get the best results for the clients are the ones that do the unconventional things oftentimes and think outside the box.
Good point.
You can get the AI out of the box or not.
I just want to mention one thing. It's not really fair to ask you this question because it doesn't deal with employment law, but it's kind of an interesting issue. Can AI entrap its users in collusion lawsuits? An example being if the three of us, me, Jonathan, and Rob, if we all own, let's say, some real estate in my city of Chandler, Arizona, and we're using AI to maximize how much we should charge for our different apartment units that we own. If we did that on a live meeting, that could be collusion. You know, if we got together and figured out how to carve up the market and which units to charge, what prices, you know, to maximize revenue, that might be collusion. But if AI does it for us, is that still collusion? Maybe it's not a fair question to you because it's not your expertise, but I just want to throw that out. If you want to say anything about it, that's fine. If not,
Well, David, if you call me up and tell me you've got an AI tool that'll get us a good deal and it does the colluding for us, I don't know. It feels like we just used a different tool to do the same thing.
Yeah. I mean, my thinking is that if I were a U.S. attorney and I saw that, I would say, well, you guys used it
Right.
and you got the result that benefited you. So yeah.
okay.
As I noted earlier in the employment context, whether you're using a stone and a chisel or a notepad and a paper or an AI tool to discriminate against employees, the anti-discrimination law says you can't discriminate. It doesn't say you can't use one tool versus another. The application is no different. I don't see that. I don't see any prosecutor taking a different view.
Okay. Well,
Absolutely.
this was a very interesting discussion. We could go on for another hour at least. But thank you to Jonathan Ben Asher and Rob Szyba for speaking to us. It was an excellent session, very informative. It could have been a very dry session, but you made it very interesting and fun to listen to and to help produce. So thank you, gentlemen, very much. We really appreciate it.
Thanks
All
so
right,
much,
let's
David.
go.
AI couldn't have made it
So
this
much.
interesting. I'll tell you that.
Oh, that's right.
Okay. All right. Thank you both, gentlemen.